Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about sentencing. Cases that should have gone to the Supreme Court of Canada, but didn't. Jason Belek was convicted of impaired driving causing bodily harm. As is a victim's right in criminal proceedings, at the sentencing hearing, the victim presented a victim impact statement, which the judge, as is their obligation, took into consideration in passing sentence on Mr. Belek. He was sentenced to a year in custody for a first offense, as well as a driving prohibition. He appealed his sentence, arguing that the sentence was out of range for the offense that he'd committed. The Court of Appeal agreed that the sentence was too harsh, reduced it to 6 months of jail, and upheld the driving prohibition as appropriate. Mr. Belek sought leave to appeal to the Supreme Court of Canada, arguing that the sentencing judge and the Court of Appeal essentially took too much consideration to the victim impact statement and the effects of the accident on the victim, essentially punishing him not for what his actions were that day, but for the consequences specifically of his actions, which is not how sentencing in these cases is supposed to work. You look at the moral blameworthiness of the offender and not the outcome of the accident on the individual who was harmed in it. Mr. Belek was not supposed to be sentenced for how much the person he hit suffered as a result of the accident. The Supreme Court of Canada declined to hear the case. And this raises an important issue, because as we see sentencing for impaired driving cases becoming increasingly lengthy, sentences for bodily harm and death offenses becoming longer and longer as the case law goes on, the real question becomes, do judges have to consider the significant impacts that victims in these collisions suffer and use that as an aggravating factor on sentence to increase the length of sentence? Because the trend seems to be moving in that direction. And that's not consistent with the principles of sentence, which are supposed to look at denunciation, deterrence, promoting a sense of responsibility in the offender, rehabilitation where necessary, and reintegration of the offender into society after separation from society, if separation from society is necessary. None of those things consider how badly somebody was injured or how long they're going to suffer with their injuries. And yet this appears to be the trend in the sentencing cases. This was an opportunity for the Supreme Court of Canada to clarify that inappropriate considerations like that should not be imported into the sentencing process, and to clarify the way that victim impact statements should be taken into account by judges sitting on sentencing hearings in determining what is an appropriate sentence and limiting the use of those victim impact statements only to what is appropriate, which is informing the court of the consequences, not in advocating for a longer sentence. The Supreme Court of Canada had the opportunity to stop what is essentially a disturbing trend in Canadian law, and unfortunately they didn't take it. This means that more people may be given longer sentences than are justified on the basis of victim impact statements and impacts on victims in impaired driving cases or in other cases resulting in bodily harm or death. And that is, frankly, something the Supreme Court of Canada should have helped us to avoid. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.